When someone wants to argue that litigation finance is either immoral or illegal, they often invoke the common law doctrines of Champerty, Barratry, and maintenance, all of which prohibit outsiders from paying litigation expenses on behalf of a litigating party. Although these doctrines are commonplace in judicial opinions discussing the legality of litigation finance, they are often misunderstood. An explanation of what they actually are helps to demonstrate why their contemporary application is unwarranted. The doctrines of maintenance, Champerty, and Barratry originated in the ancient Greek and Roman legal systems, evolved in the common law system of England during feudal times, and spread to other jurisdictions largely through the far-reaching legal influence of the British Empire. The fundamental purpose of these doctrines was to prevent aristocrats from harassing their enemies by funding unfounded litigation by others against those enemies. The three doctrines address three forms of officious intermeddling in others' lawsuits. Maintenance is the broadest of these doctrines, and it includes the act of providing financial assistance to a party to a dispute without taking an interest in that party's recovery. Champerty involves providing the same assistance with the expectation of receiving a share of any money recovered if the funded party wins. Barratry involves the repeated practice of Champerty, especially if it is undertaken by an attorney. In light of these definitions, Champerty is the doctrine with the most relevance to litigation finance. The Champerty doctrine has been steadily eroding for nearly a century in most states in the United States. The broadest and most prevalent exception to the Champerty doctrine concerns contingency fees for attorneys, which are a form of Champerty. In many jurisdictions, courts have not made comprehensive decisions about the continuing viability of Champerty or the other doctrines, ruling them inapplicable for certain purposes or in certain procedural situations, without ruling on their application in others. This means there can be substantial uncertainty about the extent to which these doctrines can be applied in any particular jurisdiction. Some general conclusions are possible, however. In those doctrines that recognize Champerty, it is always available as a defense to the enforcement of a contract between a funder and a litigant. In this context, Champerty functions much like a void as against public policy defense. In many cases, Champerty has been raised as a defense in the litigation between a funded plaintiff and a defendant. In these situations, the defendant argues that the plaintiff's claim is, in essence, forfeited because the plaintiff has entered a Champerty agreement with the funder. These arguments almost always fail in modern cases. If you need help with litigation funding, call or email me today.